did the incident went back with the jury.
All right, is that
And Your Honor, if I may be heard on that, Matthew Plott on behalf of the state does not concede that that search warrant and accompanying affidavit did in fact go back with the jury. I do see that it was made a part of the record post-trial, but there are alternative explanations for why that might have been compiled post-trial. So unless we have a witness, and we are going to hear from Mr. Shepard today, unless we have a witness that affirmatively says, that the search warrant and the accompanying affidavit did in fact go back with the jury, the state is not willing to concede that it did in fact go back.
all right, Mr. Shepard? You were the trial attorney?
You're on mute, Mr. Shepard.
Sorry, I stay on mute and then sometimes I forget. I apologize. Your Honor, I believe this was a 2 co-defendant trial. I was one of the attorneys present in the courtroom. I was appointed to represent Tavares Jones, but there was another attorney who represented the co-defendant at trial.
Yes.
All right, do we know whether or not the search warrant went back with the jury? I would assume that you looked at all the evidence that went back.
Not every page of every document. And this was at the very back of a stack of medical records. And when the state introduced the evidence, they said this is the medical records. They didn't say that it included the search warrant and the search warrant affidavit. So I took the state at its word that it was medical records. And an affidavit and a search warrant are not medical records. So what was represented to me was that it was medical records, and I looked at the front of it and maybe a couple of the pages, but I didn't thumb through and look at every piece of paper. We were in
What evidence do you have, Ms. Shubo, that the search warrant and the affidavit went back with the jury?
The trial transcript itself. What was taken back to the jury was then given to the court reporter. There's a presumption of regularity. It would be the state's burden to show it didn't happen because it's attached and it's part of the record. They would have to make an affirmative showing that the record itself, that something in the record actually didn't happen.
What does the record say about the issue?
The record is silent on the issue about whether it went back, but the actual records, the exhibit volume has it in it, which is what the court reporter would have to make the exhibit volume. So there's no way she would have it, she or he, I don't remember who the court reporter is, would have had it if it wasn't. Usually what happens is the exhibits come back from the jury room and are directly handed to the court reporter.
And Your Honor, just to posit a perfectly reasonable explanation, this record was compiled post-trial. The court reporter could have contacted Ms. Dunikoski or anyone else and requested this exhibit, and mistakenly, she could have been provided with a copy that was inclusive of the search warrant and affidavit. That does not mean that it went back with the jury. The state would suggest that either we need to have someone, again, one of the attorneys would have to affirmatively say, I saw this go back with the jury, the bailiff, a member of court staff that would say, I saw it go back, or even call a member of the jury under 24-606B to testify, yes, that did in fact go back with the jury, and if they saw it.
When was this trial?
2012 indictment, 2013, I believe, trial.
I believe that is correct, yes.
Well, I guess we could call a juror. I've never done that before. Let's say it did go back. Is that reversible error?
Based on what I laid out, I believe it's reversible error on multiple different ways, all with different standards of review. I think it goes all the way from a comment on guilt or innocence, because it was you who signed the search warrant affidavit, all the way down to plain error. And I think and everything in between, from a presumption of error to harmless error to ineffective assistance of counsel, all the way to plain error. You could describe it in multiple different ways. All of them, I personally believe, would be reversible error with regard to this, because it is actually—
Well, certainly nobody involved with the trial would have intentionally let that go back.
Exactly. No one is saying, yeah.
I never would have sanctioned that.
Exactly.
And it certainly wasn't even moved to be admitted, was it?
No, it was obviously it was obviously accidental by Mr. Shepherd and Your Honor. I don't have testimony from the state, but I have no doubt that it was accidental on their point as well. Doesn't really matter why it went back though, at least based on the defense, because one, it wouldn't be admissible, just as you said, you never would have allowed it to be admitted. And two, it's in the record of the exhibit volume that's having been admitted. Now, I think Mr. Platt might be able to rebut that presumption, but I think the presumption is there.
All right, let's do this. Let's find out who the jurors were and see if we can contact the foreperson of the jury. Okay, in the meantime, can the state and the defense see if you can negotiate a resolution to this matter?
I'm
And
happy to work on a resolution if the state would like to work on
something,
it.
Mr. Plott, you'd be willing to talk about?
We would be willing to talk about it, especially about potentially getting the jurors here. But at this point, the state isn't willing to concede that it did go back. And
All right, let's reset the, I'm looking at your other, is that your main problem with the verdict?
Yeah, so the main problem is the search warrant. We also have another IAC claim with regard to some statements made about the jail calls. And then we have a plain error issue with regard to the jury charges.
Tell me, what's the plain error?
You didn't give a charge on criminal damage to property in the first degree, and the elements were never explained. Now, that only counts for a 10-year sentence out of life plus 175. But I think it's plain error with regard to that count because the elements really aren't self-explanatory at all.
All right, let's reset this to get the jurors, a couple of the jurors in. I don't care, maybe 2 or 3 of them, and y'all talk about the case. So your main issue is, I've hit it, is the search warrant.
Yes, so the search warrant, the IAC claim, the state said basically there's more evidence here. There's more on that jail tape, but we're not letting it in due to inadmissible evidentiary issues, which was told to the jury. I think that's a problem.
The jail tape, was that where the other witness didn't want to testify because he was going to be called a snitch?
Correct.
And that's the reason he didn't testify, right?
That's the state's argument. Yes, that's what they said at trial.
That is Demetrius Dolly?
No, that is Braswell and Bogar. They both ended up testifying at trial, but their stories changed. They were much more inculpatory pre-trial at the incident, and during trial, they were much more exculpatory. And the state's argument was that happened because of these jail calls.
And the jail calls were admitted?
Yes.
They were saying it's ineffective assistance that they were admitted, and Mr. Shepherd didn't object?
No, he objected. What ended up happening is they were admitted redacted. But when they were talking about the redactions, instead of just saying nothing or, you saying like, this just happens, don't worry about it, the state actually said, due to inadmissible evidence rules, you can't hear this part of the tape.
Your Honor, I think that slightly misconstrues what actually happens. I'll let the record speak for itself on that.
I can read the quote, but I am paraphrasing.
All right, well, let's see if we can resolve the case.
Okay.
Let's see if we can resolve the case. If y'all come up with a resolution that's satisfactory to the state and the defense, I will go along with it.
Okay.
Your Honor, is there any way maybe we could do my testimony today, since the juror's testimony is going to not really involve me?
Tell me what you want. Tell me what you want to ask Mr. Shepherd, Ms. Shubo.
Can I be under oath so that way I don't have to get resubpoenaed?
Raise your right hand, please. You swear or affirm the testimony you'll give before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I so
Ms.
swear.
Shubo, what do you want to ask him?
I've got 15 questions. I'll be as quick as possible. Can you state your name for the record?
Kenneth Shepherd, Kenneth Shepherd, Sheppard.
How do you know Mr. Jones?
I was appointed to represent him by the Georgia Public Defenders Council.
Do you remember this trial?
Barely.
Do you remember what your trial strategy was for the case?
To try to challenge the state's evidence based upon reasonable doubt. We were not trying to run an alibi defense or a self-defense defense. It was straight reasonable doubt.
We talked about this before you were sworn in. Do you remember the medical records that were entered into evidence with regard to Demetrius Dolly?
Yes.
Do you remember going through them page by page to check and see if anything additional?
I had been provided with the medical records in advance of trial, and the medical records that I got in advance of trial, I did review, and there was no search warrant or search warrant affidavit attached to those records. At the time of admission, the state's attorney said move to admit medical records. She did not say anything about there being a search warrant or a search warrant affidavit hidden inside the medical records, or I would have objected. So I did not go through every single page of medical records. During a trial, the jury's watching you, and if you're sitting there thumbing through each page of 1,000 pages of medical records, you feel some ill will from the jury. So I trusted the state's attorney to have provided me and handed me what she said it was, which was medical records. I didn't, in the wildest dreams, think that there was other stuff snuck into it that was inadmissible. So I trusted her. I looked at the top page. I looked at the first 3 or 4 pages. It was medical records, but no, I did not thumb through and look at.
I clearly think that if this did happen, that it was absolutely inadvertent and there was no malicious intent.
I agree, Your Honor. I just want it on the record.
No, I understand.
Okay.
So no, I did not look at every single page when I should have.
Do you have any specific recollection of anything being removed for the exhibit before it was sent to the jury?
I have no independent recollection of this, but with 3 seasoned trial attorney, I know that we would not have tampered with evidence before it went back into the jury without putting it on the record. So if there was anything removed from an exhibit that had been admitted to the trial, as a trial attorney, if I had participated in that event at the time, I would have insisted that it goes into the record. So would my co-counsel, who was very well experienced, and so was Ms. Dunikowski, that we would have never have gone up to the exhibits and started tearing things off them and, disassembling exhibits and then sending them to the jury. So if it's in the record, then it happened. If it's not in the record, I have no specific recollection of it happening. And based on my trial practices, we would have put that on the record.
Okay. One other issue. Do you remember that a woman named Patricia Byers-Smith was called to speak during the sentencing phase of the trial?
I remember a number of people spoke during sentences. I can't remember that specific name.
If I were to tell you that Ms. Smith was not a victim or related to a victim, but is instead related to a decedent in a 2003 homicide, do you remember that?
I do.
Okay. Was there a reason you didn't object to that?
Because I failed to do so when I should have. If she is not a victim of this crime, then her impact statement should not have impacted the court sentencing. So I should have objected at that point. If I did not, it was an error, not a trial strategy.
That's all the questions I have, Your Honor.
Mr. Plott?
Thank you, Your Honor. Mr. Shepard, at the time of trial, how long had you been practicing law?
$18 years?
And was your practice primarily centered on criminal law?
Yes.
And at the time of trial, how many criminal cases did you try that resulted in a verdict?
20?
And about how many of those were murder trials?
5?
And as part of your practice of criminal law and preparing—
I apologize. You're asking about in 2013 or now?
In 2013 at the time of trial.
Then those answers are correct. They're all much higher now.
Thank you. And as part of your practice of criminal law and preparing for and conducting trials, did you routinely review evidence?
Yes.
And specifically documentary evidence?
Yes.
And do you recall any other case in which documentary evidence that you did not intend to be admitted was erroneously included and went out with the jury? There's
been lots of times with evidence that I felt should not have gone out to the jury, I objected and got overruled, and it went anyways over my objection. But this is the first time I've ever had a situation where it was just not realized by anybody that this stuff was in an exhibit that wasn't what was supposed to be there. So this is the first time of this nature where evidence went out. But evidence goes out all the time over my objection.
And do you recall in this case reviewing the medical records of Demetrius Dawley before trial?
Yes.
And do you recall seeing a medical record certification of authenticity attached to those medical records?
Yes, it was the cover page.
Did you see that during trial or before trial or both?
Both. I think there was at trial the cover page. I think it was the custodian's affidavit. But that's memory from a long time ago.
And did you review State's Exhibit 70 before it was admitted during the course of the trial, or did you only review it prior to trial?
What was State's Exhibit 70?
The medical records.
Okay. When we got the discovery, it was in the discovery. So I reviewed it during pre-trial parts of the discovery. At trial, as the state was introducing the medical records into evidence, Ms. Dunikowski walked over to the defense table, handed us a stack, and I looked at the cover page, did like this, looked at 3 or 4 pages. It was in fact medical records that I had seen before, so I assumed what was behind it was just more medical records. And then co-counsel looked at it, handed it back, and it was introduced into evidence.
And at any point before or during the course of the trial, did you see the search warrant or warrant affidavit for those records?
I had seen separately and apart in the discovery, the search warrant and the affidavit, which was separate and apart. I think there were other search warrants too. But when I saw it, it wasn't part of the medical record. It was a separate document.
So when you received this during discovery, did it come in the pages before the medical records, after, closely associated with, or totally different? I guess I'm trying to get a little clarification on that, because you're saying you saw it, but in what context did you see it in discovery?
I can't say where it was sequenced within the pile of discovery, because what we do when we get discovery, we take and we start parsing it out and putting it in little files. So the best way to describe it, and I can visually show you what we do with discovery, as you can see that we parse it out into all these little subfolders. So when we would have got it, we would have put the medical records in one subfolder and search warrant affidavits in one folder, police reports. So it comes in a pile. And if it comes on a Bates stamped disc, we just print it and we get a pile, and then we start sorting it out. So it would have gone into like this, with one for medical records, one for affidavit A, affidavit search warrant B, search warrant C, and so forth. So
thank you. And turning your attention to the jail calls in this case, do you recall there being an extended discussion between the attorneys and the courts about how these calls were actually going to be presented to the jury?
Yes, I do.
And do you recall there being a specific issue about the inability to redact these calls?
Yes, I do.
And in regard to one specific call, specifically the one placed on November 27th, 2013, do you recall that call actually being played for the jury?
Yes, but I can't say for certain that that was the date of it, but yes, there was one call that fits your description.
And after that call was played, do you recall Ms. Dunikowski asking, now there was more to it, but we can't play that due to inadmissible evidentiary rules. Is that correct? And that's the end of her question. She concluded the question with, is that correct? Do you recall that?
I believe so.
And was that question directed to you and Mr. Muhammad, who represented co-defendant Hightower, or was that question directed to the court?
I thought it was directed to defense counsel.
Okay, and do you recall when it was directed to you and Mr. Muhammad, he said something along the lines of, that's correct, and you said yes?
I believe that is what happened.
And you didn't object to Ms. Dunikowski's question to you and Mr. Muhammad?
No.
And why didn't you object to the question?
Well, there was a couple of options as to the jail calls. There was a lot of, first of all, I objected to the jail calls coming in period. And the trial court overruled my objection. So the calls were coming in. So at that point, my job, I felt, was to minimize the negative impact of the jail calls to the best of my ability without waiving my fundamental objection to them coming in at all. So how do we do that? The first thing I got to do is I got to get everything out of the jail call that's redactable. So we had a big discussion about what could be played and what could not be played. And after we got down to what could be played, it was pretty chopped up because there was a lot of things in the jail calls that weren't admissible. So we had two choices at that point. One, we could let the state's investigator testify as to what's in the call without playing it. But my concern about that is the state's investigator will always put the state's spin or interpretation onto what the call is, and it may not 100% reflect the entire context or the substance or the tone or the demeanor. For instance, sometimes a person will say something jokingly and the state's attorney will, or the state's investigator will say it like the person said it matter of fact, when it was really a joking kind of interchange or exchange where they're banter. And he'll put it as serious when it was really banter. So in many times, rather than let the district attorney's investigator put their spin on the call, I would rather have the jury hear it for themselves, and I can argue what was truly meant by it, and the state can argue, and the jury will have heard the original source material. As to the part you're talking about is the gaps, is that there's really no way to deal with the gaps because you don't know what the jurors are going to think. You don't know what the jurors are going to say that, oh, well, why didn't we hear that? And rather than have the jurors wondering why they didn't get to hear that, at the time I felt as a trial strategy would be better to play the call with the gaps. And I thought it'd be better as a trial strategy to say you can't hear that part because of the rules of evidence versus just having them wondering. Whether that's a good trial strategy or not, I don't know. But that was the strategy.
Thank you. And finally, turning to the third IAC claim, which I believe is the final IAC claim raised by Ms. Shubo, is Ms. Patricia Byers-Smith addressing the court after the jury had returned the verdict, but before the court entered the sentence. Do you recall this happening?
Barely.
And I believe you said on direct you did not object to her speaking.
I don't remember doing so, but if I did, it's in the record.
And what can you explain again why you did not object if you thought it was objectionable?
Well, at the time, the trial was lost. He had been convicted of murder. It was pretty much an expectation as to what the sentence would be. I'm not sure that, you know, her testifying was going to change much at the time. And I figured that maybe the judge would on his own understand that this person is her testimony is not actually a victim of the crimes for which he was impacted. And the other reason is that this victim was the victim of a murder, and for me to jump up and say she doesn't have a right to talk, you know, kind of would have been, you know, showing myself and possibly angering the judge at the wrong moment, because, you know, I would have basically been telling this person who's trying to get closure that sit down and shut up, you're not allowed to speak here today. And at that moment in time, I didn't want to anger the court right before he sentenced my client. So I kind of thought it might be better just to, but I realize now that I should have objected and I didn't object, and that was my fault.
Thank you. That's all the questions I have for this witness.
Anything further, Ms. Shubo?
Just a quick question. You said that this was a murder. Do you remember that it wasn't?
It was not a murder. Oh, it was an armed robbery. I apologize.
That's okay. I just wanted to make sure we're talking about the same trial.
I apologize.
Yeah,
like I said, I've done 19 murder trials. They all start to blend. That's right.
All right, but let's do this. Let's do this. Let's see if we can get 2 or 3 of the jurors to come in. The only issue that I'm interested in this motion for a new trial is the search warrant. That's the only one I'm interested in. And I don't know what the law is, whether or not there's a presumption that this went out with the jury because it's in the record or not. So you're saying you've got a presumption that he can rebut?
Yes, based on my understanding, and I can do a supplemental filing on this, is that there's a presumption that of regularity in the record, and that the state can rebut that
Give me a
presumption.
little letter brief on that,
Sure.
please. And Mr. Plott, you're going to try to get the jurors here?
Well, Your Honor, I would actually like to see Ms. Shubo's brief on this, whether the presumption is shifted to the state or not, because
Let's do that first. Like, can you get that brief in by the middle of April?
Oh, I can get it in by the end of next week.
Okay, let's get it in as soon as possible.
Okay.
And then y'all talk and see if there's any way to resolve the case. And then if we need to, if you're right on the law, then I think we need to bring in the jurors.
Okay.
And Mr. Plott, I understand you don't concede that and you want to see what she's doing.
Yes. Yes, Judge, because my understanding is that Ms. Shubo would be the one that would need to call the jurors to present affirmative evidence that it did in fact go back. But I'm happy to review her brief and have both of us discuss this. And hopefully we can come to some kind of resolution before.
Let's try to discuss it. If you need my assistance getting in the jurors, let me know, Ms. Shubo.
Okay. And
And
Mr.
I
Plott,
guess,
it's his burden.
Ms. Woods, I guess you need, Lauren, you need to contact Amy Von Kelch, the jury clerk,
Okay.
and ask her to search her records. Okay. And if I need to sign an order requiring them to appear, I will. And Mr. Shepherd, we are through with you. And y'all don't even miss me in the criminal arena anymore.
I do.
Of course we
I
do.
haven't seen you in a year and I see you twice in one day.
Well, I'm coming back.
When?
I'm coming back as soon as I can.
Yay.
All
Welcome
right, y'all
back.
take care. And let me take Jordy Moore.
Am I released?
You are released.
Can you
Who's
give
on
me
it?
30
Well,
seconds?
Judge, real quick, when I need do we need a comeback date?
Yes.
Ms. Shubo, you're going to.
I'm going to get
send-
the state and the court my brief by the end of next week. Then if Mr. Plott and I agree that it's his burden, then he'll get the jurors. And if it's my burden, then I'll get the jurors.
And you're going to talk about trying to resolve the case. Thank you,
I
Mr.
am
Shepherd.
completely open if Mr. Plott is open.
Well, he's a reasonable, fair-minded person like we all are.
Of course.
So I assume we'll communicate via email, and then if we
Communicate
need
and then
to
give him a date
schedule,
by email.
Great.
then when we need to schedule, we will.
Yep.
Is that what we're doing, Mr.
And,
Plott, Ms. Shubo?
That's fine with me.
Okay.
Yes.
All right,
Mr.
y'all take
Jones?
care.
Mr. Jones, can you hear me?
Do you all need to go in the breakout room?
I just want to tell him that I'm going to call you next
Okay.
week and we'll talk more. Okay. Okay. Thank you so much.
All right, take care.
Nice seeing you.
You
Thank
too.
you.
Okay, Judge, I'm looking for Mr. Zale. Hold on, he sent me an email. Please. So we're finished with Mr. Jones.
We have Miss Sleeper, and we're looking.
Yes, I'm waiting on Mr. Zale. Ms. Sleeper is present. Is Washington State Prison here?
Yes,
Okay. Is that you, Jordy?
yes, ma'am.
Okay, we can't see your face, dear. Okay, that's better. Okay.
All right, Mr. Zell.
Mr. Zell, you want to unmute yourself? Good afternoon, how are you?
I'm fine, thanks. How are you?
Great. Judge, did you check your email?
I don't
Please
know.
check your email before we get started
Okay.
and
now hang on.
respond.
All right. Okay. All right. Hang on a minute. What, do I have to leave the meeting?
No, just.
Push that up?
Mhm. Thank
Mm.
you.
Oh, okay. I want to make sure, Mr. Moore, you're okay with proceeding by Zoom through the computers. That's what you wanted to know, Ms. Woods, right?
Yes, Judge.
All right.
Yes,
All right.
thank you.
What is your answer, Mr. Moore?
Yes,
Rick, I
sir.
don't see him on the
Mr.
screen. Oh, there, I don't see, is that, oh, okay, there he is at the bottom.
All
Yes,
right,
sir, Mr. Schwall.
okay, all right. You're saying your main, Mr. Zell, your main argument is that the court intimidated the co-defendant into testifying?
I didn't use such strong language, but he kind of, yes, in essence.
Oh, that's okay.
And ineffective counsel, also ineffective counsel.
Who was
This
the
is an
trial
unusual
lawyer?
case, the way this case came about.
Okay, who was the trial lawyer?
It was Jackie Patterson who took over basically the second day of trial, or the first day of, right, like that week. He should be logging in any second.
Okay, I'll be right back. Give me 1 second.
Yes, all his cases are on Zoom.
Okay, they're on Zoom. They're not in person.
If you were notified about it, then that means.
I need to unmute myself. Can you hear me, Julie? Ms. Sleeper?
Yes, it's Juliana. Yes, I can hear you.
Okay,
I wasn't
all right.
ignoring you.
Are you here? Are you at the courthouse today?
No, I'm not.
Okay, all right, hold tight. Hold on.
Okay.
Mhm.
Jackie Patterson is having trouble logging in, and I do not know why. I've given him the Zoom link, the meeting ID, and the password, the same one I used.
I'm not sure why he's having trouble. I'm waiting on him to get on. You sent him the document that I sent you all for this particular case?
I just copied and pasted this link, and I just did it again here.
He might need the password. I heard one of our colleagues needing the password to get in. So
I gave it to him. I didn't have to use it, but I did give it to him also.
okay.
Ms. Sleeper, actually, Mr. Evans is at the courthouse. So we're trying to figure out a way to get him access to the computer.
Yes, I understand.
There.
I understand.
Yeah. Let's see, we can't, so we're still trying to get Mr. Patterson on. Let's see, hey. Oh.
As for Evans' case, Miss Woods,
You might want to send me a message in the chat.
yes, I'll do that, Miss Woods.
Because we're live on YouTube.
We'll do that.
Hey, I've been on the phone with him trying to help him. I've emailed it, texted it to him, sent him the link, sent him the PDF document from Ms. Woods.
Mr. Zell, the
Yes.
state will not object if he comes on by voice only through phone, because you can call in. If that's the only way he can do it, I have no objection. And that might be the quickest way to solve this problem.
I may object to that, though. I may think that we need to see, I think we may need to see him. I think that we may need to see him. It's hard to judge
Okay.
somebody by the phone. I'm sorry.
No, I agree. I've done it before for another defense
I understand.
attorney, because the burden lies on you, so it's completely up to you. I get it. But
Can they put me in a room with Mr. Can we go one of the breakout rooms? I can do it with Mr. Moore. If somebody can put, I don't know if Miss Woods is available to do that, and then I can talk to him about that. You can't do it. I know you can't do it. The host has to do it. I know. Let me text her.
okay.
Oh,
Hi, everybody. This is Nicole with Department of Corrections. It may be
That's the woman you worked with a couple of weeks ago, correct?
no, Jackie, I think we are all agreed that we would like him present. So let me see if Jackie's having any luck. I don't know. I don't think I've ever had anybody who couldn't log on before, honestly. I did a hearing this morning. No, he's not. He's sending me another message here. Technology is great, isn't it? All right, he wants to do speaker. Jordy and I both agree that if it was one issue, I'd be okay with it, but this is going to be a little complicated, I think, to do by voice. I'm getting the vaccine tomorrow. We may all be vaccinated very soon to do this in person anyway.
Mr. Zale, can you have Mr. Patterson to send me an email or forward me the email that he's used? I mean, it's kind of self-explanatory, so I'm a little confused.
Well, that makes two of us, because I sent him the link. I sent him the form that you sent me that I logged on to successfully, and I don't know why he wouldn't be able to log on. I can't explain it. I sent him that PDF document that you sent me, and I sent him a separate Zoom link. I texted it to him. I emailed it to him.
Can y'all hear me?
Yes, Your Honor, we can.
Okay.
Yes, Your Honor.
I cannot come in right yet because we're having a problem.
Well, maybe it's not just Jackie then.
I can't do the video, but what you're telling me is that you would maybe like to do this in person at, I think that oh, and we're not on the record. We're not on the record.
I don't know if this
I
needs to be
think
on
that
the
we're going to
record.
be back we're not on the record. I think we're going to be back at this in April.
I'm getting vaccinated tomorrow. I'm sure everyone in the court is being vaccinated.
They all are on Tuesday.
I think we need to see Mr. Patterson. I don't know. He's having trouble. I don't think voice will do. This is a little more complicated case than the typical in effect. Well, there I see Judge Schwall there. There we go. While I will miss doing it virtually.
All right, you want to do it in person? Miss Sleeper.
Judge, wait a minute. Someone is coming in now, so I'm not sure who this is. This might be Mr. Patterson.
If it's Zoom rooms, it's for 3 o'clock.
Zoom room is who?
Things are not going well. Let's just give them a date in April, and if you want to do it in person, I'm open to doing that in person.
So here's the thing, Judge. You all may be able to appear in person. I'm not sure what the Georgia Department of Corrections is doing. So we're at the liberty of that organization.
Well,
they may be appearing virtually, hear me out. And we know that the county only has maybe 1 or 2 of those big video screens that you all have going around to 18, 20 different divisions. So I just wanted everybody to be aware of that. So I can set a date. There is no promise that it's going to happen the way you all think it's going to happen.
Well, we'll do the best we can. And you want Mr. Patterson in person. And
I don't know why Mr. Patterson can't log in.
Visually would be fine, but I mean, I think we do. I mean, this is.
All right, that's fine. Miss Woods, give them a date.
It's going to depend on when you're available, Judge, and with all of your family hearings. So we'll have to.
We will give you an email. We'll make it as soon as possible.
That's fine, Judge. I understand. I appreciate it. I mean,
okay, we'll work with you.
We're doing all of us are doing our best during these times. Thank you.
All right, and I hadn't seen you. Your daddy passed away, didn't he?
He passed away. Thanksgiving before last, right when my son was going through chemotherapy. So 2019 was a horrible year for me.
Is everything okay with your son?
I wouldn't have said it if it wasn't. So yes, everything is okay. Went through the chemo, had to take a year off school, but he seems to be doing well.
How old is he now?
He's 24 and he's about to graduate college and he's hoping to go to law school. But the day of my dad's funeral, it was one of his chemo days. So I had to miss one of his chemo days to, funeral. So 2019 wasn't great. 2020 was the pandemic. So hopefully later.
I always thought very highly of your father.
I appreciate that, Judge. He thought very highly of you as well.
He was a good man and a great lawyer, and I'm sorry, and I thank God your son is okay.
Thank you so much.
I had 2 back surgeries last year, so I want 2020 behind us.
I know. Well, boy, we all had some bad luck here. Getting older. We're all getting older, aren't we?
I've been doing this 25 years.
I remember, Judge. I remember you on the mattress court. We've been doing it that long. It's been a while.
I've been doing it a long time.
I know.
Are you still in the DeKalb County Magistrate?
No, I'm not. No, Judge. I moved. I'm down in Savannah now, mostly.
Okay. All right. Well,
I got tired of the traffic.
I understand. Well, Miss Sleeper, he's going to say bad things about me in that hearing, so you got to help me out, okay?
I will, Judge Schwall.
I take a lesson from you, Judge. I'm very political. I know how to handle things. I'm pretty good at that stuff. I'm very good at it.
All right, y'all take care.
Thank you, Judge.
Who is my DA on Antonio Evans?
It's me again, Your Honor.
Okay. All right.
So, Your Honor, may I speak about Antonio Evans' case yet, or do I?
Not yet.
Okay.
Not yet. We're trying to get things together.
Okay.
All right, this is the case of Antonio Evans. Mr. Evans is present physically in the courtroom.
Yes, ma'am.
All right, Ms. Sleeper, please tell me what you want to tell me.
Yes, Your Honor. So Juliana Sleeper on behalf of the state. This matter is a pro se motion, so I would like to provide quick background information for the court. Defendant was indicted on May 3rd, 2019 for murder and other related charges. The trial was held in December of 2019. Jury found him guilty of only possession of firearm by convicted felon, and he was acquitted of all the other charges. Final disposition was entered on December 10, 2019. Your Honor sentenced him to 10 to serve 5. And on March 13, 2020, defendant filed a motion for an out-of-time appeal claiming ineffective assistance of counsel. Pursuant to Collier decision by Supreme Court in 2019, which is 307 Georgia.363, this court must hold an evidentiary hearing to determine whether defendant was deprived of his right to appeal due to his counsel's ineffective assistance. Although it's not state's burden, the state has called defendant's trial counsel, Michael Eddings, to come to court today to testify as witness. However, it seems like it was unsuccessful because Mr. Eddings, although represented to me that he will be available on Zoom at 3 o'clock today, he's not here. He told me that last week, and I tried calling him all week this week, and he's been avoiding me. Looking back, I think I should have subpoenaed him. But once again, it's not state's burden, but I wanted to accommodate the defendant and do that for him.
Well, I mean, it'd be awfully hard to argue ineffective assistance of counsel when you get acquitted of murder.
I think so too. But this is for a motion for out-of-time appeal. And what he's trying to say, I guess the defendant is trying to say, is he was never informed of his appellate rights and he wanted to appeal, but his counsel failed to do so. I think it's the argument. And
let's do this. You subpoena the witness, the lawyer.
Yes.
And Ms. Woods will do a in-person hearing. Are you coming to the courthouse, Ms. Sleeper?
I can, Your Honor.
Okay, I don't want anybody coming here in person who's not comfortable with it.
I am comfortable, Your Honor. My husband will be vaccinated in 3 weeks, so I should be fine.
Okay, you're vaccinated.
I am vaccinated, but I just worry about my husband because he has underlying conditions.
Okay.
But
Well,
he'll be good soon.
all right, Ms. Woods, do you have Mr. Evans' email?
No, I don't need, no, what will happen is I will schedule it for another hearing date.
You know how
When
to
you're
get
available,
in touch with
Judge.
Mr. Evans?
So
Okay.
he'll get notice via,
You'll get notice, Mr.
via
Evans.
mail. I
via
will
mail.
not because I'm trying to protect our virtual hearings as much as possible. I don't file the Zoom meeting IDs and passwords. So that information will be disseminated via email.
Okay, you'll get an
So-
email. Well, we have his email. All right, Ms.
Okay.
Sleeper.
Your Honor, if this is in person, does the witness also have to appear in person? I just don't want to give an extra excuse to Mr. Eddings.
You know what? If he doesn't want to do it in person, we can do it by Zoom.
Okay.
Yes,
I
I will have the Zoom. I will have the Zoom link, the Zoom going.
All right,
Oh,
we'll
so
do
this
it by
will be-
Zoom.
So we'll do it by Zoom?
Yeah, we'll do it by Zoom.
And defendant's okay with that, I guess.
All right, you can come in person if you want on the date it is, whatever you want to do, Mr. Evans, okay? All right, so I think, Lizzie, are you on the Shakir Cole case?
Yes, sir. I am on Shakir Cole.
And is Mr. Cole on? But you're
Judge.
excused, Mr. Evans.
Judge, we actually have a hearing at 3:30 with Tavares Jones. That's with ADA Burke, Dotery, yeah, and then at 3:45 is Shakir Cole. So
Wait, 3:30, do I have that paperwork?
I think I emailed you everything.
I
It's
have
a
the
motion to
calendar. Jordy Moore, Dominic Jones, Antonio Evans, and Shakir Cole. I do not see the other one.
Okay, I will resend it.
Resend that to me and copy Candace so she'll print it out. For me.
Yes.
All right, so Ms. Sleeper, we're done?
Yes, Your Honor. As soon as I have the new date, I'll subpoena Mr. Eddings.
Okay, thank you. And
Thank you.
are you on the other one too, Ms.
No,
Rosenwald?
Your Honor. Oh,
Okay, you're excused.
may I be excused? Thank
Yes,
you.
thank you. Are you on the 332?
No, Your Honor, I'm just on Shakir Cole's case.
Okay.
Burke that's scheduled at 3:30, Judge. So you have a little
right.
bit of a break.
We'll come back in just a minute, okay?
Okay.
Jesus have mercy.
Ms. Woods, this is Nicole Beasley from DOC. Can you give me a status if you guys still need the inmate that's at Washington State Prison that was in our
Which inmate is that? Wait a minute. Which inmate is that at Washington State? Let me look real quick. We need Shakir Cole. And we need Tavares Jones.
So we just need to. Okay, so
those are the two that we need. We're done with Jordy Moore.
Okay, we're done with Jordy Moore. Okay, all right. Thank you so much.
No, thank you, Miss Beasley.
Yes.
Good afternoon, everyone. I'm Judge Schwall'S court reporter. All that I'm asking is that everyone silence their phones, and if they have notifications that alert them on their laptop, to mute those. My sole purpose here is to take this matter down. So if I can't hear, I can't take down. I also ask that everyone speaks one at a time so that I'm able to take it down for the record. The problem is with Zoom is when several people are talking at the same time, it causes a technical interruption where I can't hear anything. And if I can't hear anything, I can't take down. So please place your view in gallery view so that I'm able to see you, and then you're able to see me when I put my hands up, meaning I can't hear anything. So please speak one at a time. If there's any spellings I'm not familiar with or locations, I may message you. So please have your chat up so I know the correct spelling of the matters that we're discussing. Judge Schwall will be with us shortly. Thank you.
Hey, Mr. Jacobs, Mr. Steele, Ms.
Hey, April,
Lizzie,
how are
we
you?
saw each other earlier today, this morning. Lizzie is going to be handling Mr. Cole, is that right?
Yes, ma'am.
Okay, and so before we get into that matter, we have one other matter, Tavares Jones with David. And so I think we're waiting for his honor to log in. He's getting used to the Zoom, kind of, sort of. He's not as tech savvy as we are. So give us just a moment. Is there anybody, what time are your witnesses, Mr. Steele, logging in? Now, are they, since you just filed another motion?
And I did just file another motion. It's on sentencing, and it's a merger issue. And that's just a legal issue. So there's no witnesses.
Okay.
I apologize to you and the state for doing that. I was reviewing my work, and I don't know how I didn't have that in already, but I believe that it's a meritorious merger issue that will help Mr. Cole's sentence a great deal. But with that being said, I also filed a motion today. There is a child, no longer a child, but at the time an alleged victim, AB, and there was evidence that was given to the Honorable Trial Counsel, Mr. Jacobs. AB's grandparents, we couldn't find AB, we found where she lives. We served a subpoena. Her grandparents wouldn't let our investigator in, which is COVID, I understand that. I don't know, we tried to get her this, I thought it was in person, actually. So we subpoenaed her to come to court. And then I don't know if she has a Zoom link. That's what I notified you earlier today.
Okay. Well,
Yeah.
the Zoom links are not filed on purpose to try to protect the integrity of the hearing.
Well,
yeah.
Unless the state has information on AB coming here, I may ask the court permission to hold the record open to subpoena her to either another Zoom, but this time be armed with the Zoom at the time, or come. But I think the state is trying to tell us.
Yeah. And I'll explain this to the court as well, but the victim's mother did contact our office and confirm that the victim was properly subpoenaed by Mr. Steele. We advised her that she needed to comply with that subpoena. So, I mean,
so are we expecting her in the courthouse?
She was not particularly interested in speaking with us, but we did advise her that she needed to comply with the subpoena, and the mother advised that Mr. Steele's investigator explained to the victim's grandparents the importance of complying with subpoena. So she was very much served and very much aware she had to be here, and we told her, we didn't subpoena her, but we were like, if Mr. Steele subpoenaed her, you got to come to court, So I don't know if she'll show up, but I have no further information on her, but we're gonna.
I don't know if Ms. Sanders is listening to this, so let me send a message to the office to let them know to be on the lookout for her.
We're gonna obviously object to keeping the record open, and I know Mr. Steele did just file a motion this afternoon, so when the judge comes out, I will be asking him to have an opportunity to brief that issue, because while I'm good, I don't think I can't look at legal issues while I'm literally doing something else an hour before the hearing.
All right. Okay. Hold tight, guys. Hold tight.
Thank you.
Thank you for that information, Madam District Attorney.
All right, we apologize for the delay. We've had a lot going on today. I see Mr. Steele.
Judge, we are starting with position 2 on this afternoon's calendar, and that's Tavares Jones. He is present. Is that, let me take him off mute. Mr. Jones, that's you at Smith State Prison, correct? You can nod your head or, okay.
All right, you hear us, Mr. Jones, and Ms. Rosenwasser, you on this case? Or Mr. Smith?
Mr. Smith is on this case, Judge.
All right, why do you want to withdraw your guilty plea, Mr. Jones?
You said, why do I want to withdraw it?
Yes.
To see if I can get my sentence modified or lower.
Mr. Kentucky Smith, what was he sentenced to?
He was sentenced to 20 years, 18 to serve, 2 years probated. And he actually filed a motion to withdraw his plea. And Judge, before we get into this,
You're frozen.
Substantive matters, we may have a procedural matter that we have counsel, so he needs to let us know whether he wishes to proceed today without counsel or if he insists upon having counsel.
Do you want to proceed today without a lawyer, or do you want a lawyer appointed?
Yes, sir.
You want a lawyer?
I would like a lawyer. Yes, Your Honor, I would like a lawyer.
All right, how do we do that, Mr. Kentucky Smith?
I guess we could go to the public defender's office.
Will you refer the public defender's office to Mr. Jones and let him know that he's at Smith State
Find out if they can represent him. If not, well, for them to make those arrangements for his representation.
Okay, well, let's do that. And Ms. Woods will send out a notice. How will Mr. Jones find out, Ms. Woods?
I don't know, Judge. I will have to contact Mr. Phillips because here, yeah, I'll have to send an email to see if that's doable.
All right, let's send an email to Mr. Phillips.
Right.
How do we get in touch with Mr. Jones?
I can send him something in the mail.
All right, we have
That's
your
the only
address.
thing that we have.
Judge, you can.
And if he gets representation, that attorney will reach out to him.
All right, that's fine. All right.
And Judge, I'm bringing this to your attention because otherwise it'll just go up to the Court of Appeals and they'll send it right back to us if we don't do it that way.
No, I understand, and I appreciate that.
Yes, sir.
Sir. I appreciate it. So let's do that, and Ms. Woods, work with Mr. Kentucky Smith, and let's see what we can do.
Okay. All right, we'll do that. Have a good day, Mr. Jones. Have a good day, Mr. Smith.
Okay.
Thank you.
All right.
Bye-bye.
All right.
Thank you.
Shakir Cole, is he on?
hold on, Judge, I'm looking to see which.
So Mr. Jacobs, were you the trial attorney?
Yes, I was, Your Honor.
And Mr. Steele, good afternoon.
He is, Judge. Let me see if I can get access to start the video.
Good
Mr.
afternoon.
Shakir Cole. Are you Shakir Cole?
Yeah. What happened to
Mute
him?
yourself. He's muted.
No, we lost. Oh, there he is.
He's there.
Okay.
Ask to unmute. Ask to unmute.
Unmute, please.
Yes, sir. Can you hear me?
All right, we can hear you now. All right. So, Mr. Steele. Good afternoon, sir.
Good afternoon, Your Honor. Good afternoon, everyone. Good afternoon, Mr. Cole.
Tell
Good
me,
afternoon, sir.
tell me as succinctly as possible, your best argument.
Say something, Cole. I did. They can hear me.
All right, so tell me, Mr. Steele, Ms. Rosenwasser, you're on the case?
Yes, Your Honor. I think we may need to have other people muted too. I think if Mr. Steele's going to talk, we might get a lot of feedback.
All right, everybody mute except for Mr. Steele.
Oh.
Okay, Brian,
Yes, sir.
tell me succinctly what your best argument is.
So, Your Honor, there's a sentencing issue. Now, I filed it today, and I don't know how. It was in my notes. I was reviewing everything, and I realized I didn't put the court on notice of it, and I apologize to everyone. But, Your Honor, as the court knows, Scott versus State was decided, and it's cited in my fourth amended motion for new trial. It's 306 Georgia 507 Division
So is
1.
it an amended motion for a new trial or is it sentencing?
Both.
Okay, tell me, but let's take the sentencing, tell me, let me see. Paragraph 4 of your fourth amended motion for a new trial. Tell me what you're trying to have the sentence do.
So your honorable court sentenced Mr. Cole on 5 counts. It's count 2, 3, 4, 5, and 6. They were all child molestation counts. Count 1 mistried, Your Honor. And the court gave a sentence of, I think almost 100 years, if I'm right. And ran them all consecutive. It's 20 years to serve 19 years on each count. So it's 100 years to serve 95 years. Your Honor, since the trial, the Supreme Court said that when we're dealing with the same crime at about the same time, but different instances like this is kissing and touching the buttocks or et cetera, you have to look at the unit of prosecution to determine whether these are merged, same crime merges. And it's my opinion, and I went through the whole transcript, that when the court does it, and I could explain it, count 1 and 2 should merge. So we should have 1 count, maximum 20 years. Count 3, 4, and 5 should merge into 1 count. They're 2 different alleged victims. And so therefore we're dealing not with a 100-year potential sentence, but we're dealing with a possible 40. I know 40 years is still a tremendous amount of time, but compared to the current sentence, it would be a great help to us.
Ms. Rosenwasser, have you had a chance to review that case?
So Your Honor, I received this motion at about 1:49 today. So and Your Honor knows I've basically been here since then. I have briefly reviewed it. I can tell the court that based on my 1 minute of review, I think at least the counts with Ayanna are not affected by Scott versus State, as that was really decided in a case that actually just came out last week called Zerberini versus State. That's actually another one of Mr. Steele's cases. But I would ask that the state had the opportunity to file a brief on that 4th issue so that I can do a deep
All
dive
right,
into the.
well, Mr. Steele's a smart lawyer and he wouldn't mislead the court. So he thinks he's right, but he's always right. Right?
I like to think I'm right as well, Your Honor. So if I could have an opportunity to please.
I'll let you do
brief
that. I'll let you do that. I'm not going to rule on that today. Tell me about your motion for a new trial, Brian. Tell me your strongest argument.
Okay, so Your Honor, I believe when the testimony comes out, the strongest arguments are going to be the following issue on the amended motion for new trial. Sir, issue number 2, 3, and 4, they're separate, but they really are the same thing. The two experts and then the detective really came out that Mr. Cole committed these crimes, and specifically the crescendo, Your Honor, would be when the detective, it's in issue number 4, the amended motion for new trial, and I give all the transfer pages, and it's specifically transfer page 523, lines 14 through 17. The detective said that there are additional unknown, these are not quotes, but additional unknown victims that Mr. Cole preyed upon. And that just is other act evidence that never was vetted by the court. It was not objected to. So, and Mr. Jacobs was a great lawyer, a tremendous lawyer, but I believe that should topple the convictions. In addition, on issue number 5, it goes with it as well. Miss Brodeur, which is Brodeur, testified that if her daughter made these claims of sexual molestation at the hands of Mr. Cole, then they are true because her daughter said it. And I give the transfer pages there. So it kind of goes in the same thing that these children are truthful and Mr. Cole is a serial violator of the criminal laws. Then, Your Honor, what I think is a fascinating issue is the prosecutor says, and this is a small part of the transfer to 666, lines 3 through 14, Your Honor. And the prosecutor said, and this is a quote, in closing argument, no objection, though, sir. So you have to go under the rubric of ineffective assistance. Again, everyone here has a job. Everyone here has a duty. And it's my job to present credible evidence to you. My duty is to the citizens of Fulton County, not just you guys sitting here in the jury box, but as well to the defendant. And I have a duty to everyone in this courtroom to ensure that I present credible evidence and give this defendant a fair trial. My job is also outside this courtroom. Before I present this evidence to you, my job is to speak to everyone involved in this case and ensure that they are credible before I bring them to you. So to find credible evidence and then present it to you guys here at trial. I've done this, for a short period of time, maybe longer than a short period of time. I've never seen that to be in our whole country, that to be a proper closing argument. The prosecution cannot vouch for the truthfulness of their witness or themselves. In the next paragraph, the prosecutor said that the defense has a duty, and his duty is to his client. His duty is not to the citizens of Fulton County. His duty is to zealously represent his client, and that's exactly what he did in this case. That may be a truthful statement, but in context, it really sounds like Mr. Jacobs is not about credible evidence. Mr. Jacobs put up 7 witnesses, by the way, at trial. So, Your Honor, those are really big evidence issues. I have another issue that I think is important for the court to wrestle with, but I don't believe that the witnesses here. So I'll tell you that Mr. Jacobs, I did not do this. This is Mr. Jacobs' work. He spoke with that alleged victim. She's an alleged victim in the indictment, count 1 and 2. And that alleged victim gave an audio statement. I've given it to this honorable court. I've given it to the honorable prosecutor. This alleged victim also signed an affidavit. I got that from also Attorney Jacobs, saying that the state pressured her to change her truthful testimony and make it favorable for the state. I subpoenaed that alleged victim to come before your court today. To her credit, she should be in your courtroom because I didn't have the Zoom link. So we went out yesterday when we got the Zoom link and tried to give it to her. They would not come to the door. So to my knowledge, they do not have the Zoom link, but she was subpoenaed to your courtroom. And I don't know if she's in your courtroom, but I'm assuming she's
No,
not.
sir. No, sir. Is that witness crucial to your case?
Yeah, yes, because otherwise I presume that the prosecution will say that it's all hearsay, which, I'm agreeing with it. So, yes, I need that witness here.
How long is your questioning for Mr. Jacobs?
An hour, I believe.
Well, why don't we put all of this on a calendar when the state can be ready on the sentencing part, and when we can have your witness, you did subpoena the witness. Do you want to submit me a court order saying that she shall comply with it and appear at whatever date Ms. Woods does, by Zoom or in person?
I'll do whatever you want. And before your honorable court, before we went on the record, I want to thank the prosecutor. She made an announcement that, in fact, the alleged victim does acknowledge he was properly served, was told by our investigator the importance of complying with subpoena, and the state also told them the importance of complying with the subpoena.
How long have you been with that office, Ms. Rosenwasser?
Your Honor, I just started at Fulton about the end of February. I was with the Attorney General before that and Clayton DA for a while before that.
The Clayton DA is my friend, Tasha Mosley.
Okay, I was only with Miss Mosley for a few months because that was
I
right
helped
when
her get appointed.
I'm sorry, Your Honor.
I said I helped her get appointed.
Yeah, I mean, I didn't work for her too long because I ended up going to the Attorney General last February. So I actually interned for her when she was the Solicitor General though, and she was great. So
I helped new solicitors, what's his name, Charles Brooks, get appointed.
yes.
And
Also,
Chris Carr is a great friend. All right, let's get this witness. Let's do a brief about replying.
Yes, Your Honor.
I want y'all to sit down and the two of y'all talk about what his issues are. Okay. And if you have any belief that his issues are credible, then I think y'all ought to talk and try to work the case out.
Yes, Your Honor, and I will evaluate those sentencing issues in particular. I've been able to go through all the other issues, but I definitely need to just take a look at those sentencing issues and get back.
If y'all come to a resolution that you both agree on, then I'll go along with it.
Thank you, Your Honor.
All right, because Brian wants to get me reversed, but I'm not gonna let that happen. All right, so Ms. Woods will communicate with all of y'all. Let's get a brief in can we do that by April 15th?
Absolutely, Your Honor.
And let's try to set a hearing as soon as we can, Ms. Woods, on that. And Mr. Jacobs, I thank you for your cooperation too.
Absolutely, Your Honor. Anytime.
All right, y'all have a great weekend and good to see everybody, okay?
Thank you, Your Honor.
All right. Thank you, Your Honor.
I'm coming back to criminal and civil, I can tell you that. As soon as possible.
Good.
You can read between the lines on that one. Y'all take care. Thank you.
Thank you, Your Honor.